Good morning, everyone, and welcome to North Alabama Law Review presented by Johnston and Weston. Today, we have two of our top attorneys. You know who they are, Mr. Christopher Weston and Mr. Bennett Driggers. Welcome, guys.
Good morning.
Thanks for having us back.
So let's jump into today's trending legal topic. We're going to talk about civil case procedures and the steps that are associated with them. Guys, you want to start?
Bennett, you want me on this one or you want to take this one?
Go for it.
Okay, so again, civil law is a tremendous amount of what I do. And, you know, in the last episode, we had done the trending legal topic of criminal law and criminal procedure. This time we're doing civil procedure. So welcome to one of the first classes you ever have in law school is civil procedure. Extremely important, obviously, to know these steps. They can make or break a case in certain circumstances. And again, tremendous amounts of case law in this, rules. There is a lot. There is a lot that goes into the rules of civil procedure because it is literally the entire structure for how you run a case. Okay, it's different from the claims or the claims elements. This is more the vehicle by which your case makes it from the starting point up through trial and some type of ruling. Okay, I am going to, by necessity, have to give you a kind of a brief overview, obviously, since we don't have a couple of years to engage in law school classes. But what I am going to do is give you the breakdown of what most people ask me when we are in a consultation. They want to know what they're dealing with because, again, there is cost associated, there's time associated, there's lost time off work associated with it, there's stress associated with it. Sometimes, and this is unfortunate, but they have an injured family member or someone who they're worried is going to pass, and they want to know how long this case is going to take. And so kind of like what I did with criminal law, I'm going to give you just kind of a breakdown of the steps in the civil process, more so than going over specific rules. Now, for those of our viewers at home who are sophisticated, if you have a specific question, please submit it to us. Again, I'll be happy to go over it. So other attorneys at my office will be happy to go over it. Me and Bennett might go over it together, to be perfectly honest with you, and be happy to answer it. You know, if you have more detailed procedural questions, we are more than happy to look at them. So that being said, what I tell a client or someone at a consultation, which is kind of how I'm going to treat this, Sean, is just like I'm in a consultation. There are four main stages to a civil case, okay? Stage number one, deciding if you have a claim, okay? Again, just because you know something does not necessarily mean you can prove it. Or just because something is wrong does not necessarily mean you are set up for your defense. Okay, and so that initial stage a lot of times is document collection, obviously discussing with the client, discussing with other people who may have been involved or saw what happened, deciding which elements for which claim fit your case the best, because again, each one of them has a different statute of limitations. Depending on what type, like negligence has a 2-year statute of limitations. For those of you who don't know what a statute of limitations is a limiter on when you are allowed to bring a claim. For negligence, it is you cannot bring a claim past 2 years. Doesn't mean your claim has to be done within those 2 years. It just means you need to have filed your lawsuit within those 2 years, okay? Some have a 6-month notice of claim statute. Some of them, you know, when you're dealing especially with any kind of municipal or, you know, governmental body, a lot of times there's a 6-month notice of claim. If you're dealing with a contract, you're dealing with 6 years statute of limitations, or a contract under seal, which is a little bit more rare, but all of a sudden now it's a 10-year statute of limitations, okay? And so the first part is deciding what claims you have and where they fit. A lot of times that is looking at documents, okay? Front-loading the case is what we call it at my office. We are front-loading this case, meaning we are getting everything together and we are seeing what fits best, because oftentimes you do not have just one claim that you're going to press. A lot of times if you have breach of contract, you might have fraud, you might have conversion, you might have suppression, you might have deceit. deceit, you might have a breach of contract, but then also negligence or a breach of the implied warranty of workmanship, which cannot be waived under a contract. We have to look at exclusions, limiters. There's a lot to look at before we decide what your claims are going to look like. And that's stage one, deciding what you have and what we should do with it. Okay? And ultimately, the great part is that decision is going to be up to you as long as it's not frivolous. Okay? After we decide that, what's going to usually happen, and I laugh, Bennett will know why I'm laughing, is you send out a demand letter. I am not personally a huge fan of demand letters unless they're required, like in a personal injury case involving, a car wreck or insurance. Me and Allison and me and Bennett talk about this all the time, that if it hits my desk, someone's probably getting sued, to be perfectly honest with you. I'm not sure that's the right way to be, but that's kind of how I am. But usually a demand letter. And if that goes nowhere, then lawsuit. So the first real practical step is you are filing your lawsuit, okay? And so that kind of, I say 4 stages, but realistically, practically, the first 2 combine into stage 1. The investigation, the document review, the drafting of the complaint, and sometimes drafting of your first set of discovery, which are either interrogatories, which are questions that have to be answered under oath, or are requests for production or requests for admission. Requests for admissions are things you're asking the other side to admit so that you don't have to prove them at trial. It's a cost saving, but also if they deny them unreasonably and it's clear they should have admitted them later on in the litigation, they can be responsible for those costs it took you to have to prove things they should have admitted. So they're very, very useful for reclaiming attorney's fees in a case where otherwise you might not be able to. And then the request for production of documents is just what it sounds like. We need things from you, you need to turn them over, or let us on the land, or let us, get things from you, or let us go look at things where we couldn't just like walk into your business and evaluate, the 3rd floor management hall where someone tripped and fell. It says, hey, let us in here and let us look at this, okay? And so we have a big piece of that. But usually your first stage is going to be the investigation, the decision-making, the drafting, and the filing of the lawsuit, as well as service on the other party. Rule 4 of the Alabama Rules of Civil Procedure is a very important one. That's why I happened to mention that one, where you have to serve the other party. That is to give what's called personal jurisdiction. In most cases, it's to grant personal jurisdiction that they have been served, meaning they have official notice that this lawsuit is happening against them. And then that's basically stage 1. A lot of times there'll be some negotiation in there somewhere, injunctions, a few other things that can happen. But that is usually stage 1, and that's kind of where the first kind of stage of billing tends to taper off. And then, Bennett, you seem like you got something.
I do.
Shoot,
I want
man.
to talk for a minute about the practical side at first. So, when you think that you've been done wrong, okay, let's say this. You might perceive that you've been done wrong, but there may not be any legal action you can take. It's just going to depend on the circumstances. So, but if you feel like a contract's gone south or something, your work you're having done on your house has gone south, the most important thing ahead of time is to keep good records, pictures, document, do a timeline of the events. And then when you come into our office and see an attorney, that's going to be very helpful in determining, 1, when our statute runs out, 2, what claims we can make, and 3, we can start building a file on those records that you've already kept. That's important to protect yourself when preparing to go through a possible lawsuit, and that protection is done by documentation of the events and keeping good records. That's going to be one of the most important things that you can do ahead of time.
Yeah, absolutely. And again, cost-saving measure on your end. If we don't have to go find them ourselves, it's extraordinarily helpful. And so, yes, keeping documents, knowing what you're looking at. So is that being said, is after that first stage that you're dealing with is you go into what I call the second stage. And again, these are not legal terms I'm using. I'm just giving a breakdown of the stages of a case, practically speaking. The second stage is what is known as the discovery phase. That's what I call it. That's what I think most lawyers call it, is the discovery phase, where you have, if you did not file interrogatories, requests for production, requests for admission, you will do so during that stage after service occurs. And then the other side will have 30 days to answer those, usually speaking. And then they will usually propound those on, you as well, and you'll have to answer those. They'll have to answer them. You'll usually start shooting out subpoenas at that point. You'll be looking into experts if there are any to be had, if you've not done that already. And you'll start taking what's known as depositions. This is a question we get a lot, but I know I certainly get it a lot, is, what is a deposition? Is it in front of a judge? Well, it can be, but it's usually not. It's done in front of a court reporter. It is testimony given under oath is what it is. So you have a court reporter, you have the opposing attorney asking you questions and vice versa. And then you have, all of this recorded to be used at a later date if the person being deposed changes their story. Okay, or unfortunately it does happen, they pass away and there's no other way to record their testimony. You also have that when you are dealing with medical experts, doctors, because they cannot usually be subpoenaed into court because they have medical emergencies to deal with. So you use just their deposition in trial. And that process, depending on how big your case is, how many people involved, I mean, we've had it where we've had dozens of depositions, thousands and thousands of pages of documents. And we've also had it where it's 0 depositions and, you get 100 pages of whatever someone had in their computer. It just depends on the case. But that's the second stage. And then the third stage is summary judgment. Your motions where they say, well, judge, you need to rule before it gets to a jury or trial for whatever matter of law. Okay, and so you have a summary judgment motion. Again, you have motions in limine, like we've spoken about before. You have jury selection if it's a jury trial, and you have post-trial motions, which are a little bit more, usually a little bit more extensive or varied, because you have motions to alter, amend, or vacate if ruling doesn't go in your favor, motions for new trial, of course, and then the appeals process. Maybe you look like you had something else jumping on there.
I do. I want to jump right in. So during this process throughout, you're also able to negotiate with the other side. Some courts order mediation, which is a procedure where you go and you're in one conference room with your attorney and the other party's in another conference room with their attorney, and this mediator is going back and forth trying to see if we can come to some kind of settlement of the case. As far as discovery timelines too, there are some judges that issue standing orders that have timelines that you have to meet through this process. Some will ask the parties to agree on a scheduling order that says, okay, this has to be done by this date, this has to be done by this date. So don't feel like your attorney's pressuring you or anything when they're asking for this stuff. They're on a timeline, a lot of times ordered by the court to respond to these things. So make sure you're aware we're not trying to drive you crazy and ask for this stuff because we just want a bill or anything like that. We're asking for reasons. So we can try to resolve your case through either mediation or trial or some kind of agreement with the parties. It's, so it's all for your benefit.
And I will say this, to go off that exact point is that, there are some other things that happen in between. One of those things can be what's known as an injunction or a 12B6. Injunctions, if someone asks a question along those lines, I'll be happy to answer it. But, 12B6 is very common. Injunctions are less common. But a 12B6 is something where they do a motion to dismiss very early in the case. Like it has to be done right off the bat in most instances, where they say, look, this is frivolous, or they're missing elements, or there's no way this was us. I mean, there's a lot of different reasons you can do it, but it can be a 12B6, well, also known as a motion to dismiss, usually for quote unquote failure to state a claim for which relief can be granted. There are other service issues and things you can bring up, but it's very important to address that at the beginning of a case. I say all of that because it's something we get, not from most clients, but from the occasional client, is, they get a little bit sticker shocked right at the beginning of a case. And, right along what you said is these things we're doing, and any attorney that I know of, I won't say all because I don't know all attorneys, but, they don't just bill to bill, because we have a lot of cases, a lot of work that there's no real need to go scrounge for that kind of billing. It's that because you have these stages in a case, you'll see a large number of charges at the beginning, kind of a large number of charges somewhere in the middle, and then a lot of charges at the end. And so your case does take little dips here and there to allow you to catch your financial breath, okay? And so don't allow that to scare you off from seeking an attorney, because as Bennett said, you can, mediate and attempt to settle at any point in the case. I mean, you can always do that. So just kind of a basic understanding of how the timing on billing works is that there is going to be an upfront, unless it's a contingent case where the attorney's taking a percentage, you are going to have some money up front, but it's not going to stay that way throughout your entire case, unless of course you're dealing with something on the national level or some massive litigation where it's going to be 5-10 years long and you're dealing with hundreds or thousands of people.
I think that goes into a question that we get a lot of times is, how long will a civil procedure or a civil case typically take to wrap up from start to finish? Because, we know when people come in, they have problems, they're relying on their attorney to get it resolved. And 2 years can seem like 20 to the person who's having the problem. But again, we know we can't guarantee outcomes and solutions, but what is a general conclusion timeline that people can anticipate on getting these wrapped up?
Okay. Bennett, you want this one?
That's a tough answer. Number one, it's going to depend on the type of case and how complicated it is. There's cases that are very easily, very quickly resolved, but there's cases that are very complicated and you're running into that 5-year mark, as Chris said. So you have to be very careful when you're talking to somebody about their case, and it's hard to say. It's really a hard question to answer as far as the timeline, and that's what I tell people in consults is, I wish I could give you a timeline, but it wouldn't be fair to you, because we could have this done after a demand letter, which Chris loves, as he spoke about earlier. we could have this done shortly after we file a lawsuit, or we could be in litigation for 2 years. You just don't know. And we're not trying to not answer the client's or the potential client's question in that consultation. It's just the fact of the matter is every case is different depending on the facts, who you're suing, who the other attorney is on the other side. There's a lot of factors that go into the timing of getting a case resolved. So it's a real hard question to answer, but that's the best I can do.
They can't all be easy.
No.
I'm going to jump in on that too, because, a lot of times clients feel that, that question is hedged by attorneys a lot. Understand it's not being, is that there are ethical rules for attorneys, okay? And one of those is we are not legally allowed to guarantee a time frame in which your case is going to be resolved. And unfortunately, if you tell someone a specific time frame, that's all they have in their brain a lot of times. And so they take that as a guarantee. And so we're very hesitant a lot of times as lawyers to come in and answer that question, because we don't want to make an ethical misstep, because we are not in control of the dockets. So that everyone at home understands, the reason we're not allowed to do that ethically is that we're not in control of the dockets. We shouldn't be. The judge or the fact finder is sometimes a fact finder, but the judge is in control of the dockets. Clerks are in control of dockets. Judicial assistants are in control of dockets. And even inadvertently imparting some or implying that we can affect those in some form or fashion is not something we are allowed to do. And so like Bennett said, it really depends on the type of case. But I will give a little something that most times, people don't hear, is that if you're dealing with civil court, circuit civil court, you're usually looking at between 14 to 24 months for complete resolution in Madison County, usually. And again, for very good cause. It allows the time that is needed to conclude a case. But again, a lot of times the judges, if it's a very straightforward case, they will get it out much, much, much quicker. So that's no guarantee. But just kind of average litigation between two parties, nothing too big, nothing too small, or nothing too, straightforward, you can count as a client on somewhere between 14 to 24 months. Something smaller like in district court, you can usually count somewhere between 6 to 9 months. And in small claims court, a lot of times 90 to 120 days, okay? Again, that is in Madison County. That is very general answer for you viewers at home. There is no guarantee on that. And again, sometimes it can be a lot quicker or a lot longer, very much depending on the complexity of your case, the number of litigants at that moment, and then sometimes the length of other cases. Like if there's going to be a capital murder trial that's going to last, a month, that can obviously affect the docketing of your case.
All right, thank you guys. Thank you for all the information regarding civil procedure. So we're going to go ahead and jump into some of the questions submitted by our viewers. Our first question is going to go to Bennett. What happens if a loved one dies with a small estate or little assets to their name?
That's a good question, and I'm going to answer it.
I'm glad you are.
So basically, when you talk about a small estate, there's caps that Alabama puts on that. They give you an amount in the code, and it changes periodically for inflation. So the amount could be like $30,000. Let's just use that figure. And that would classify as a small estate in Alabama. You still need an attorney to file a small estate. So if your loved one's died, the best thing to do is just come in and counsel with them. One, up front, if there is a will, the executor may or may not know the value of the estate right away. So you don't know yet if there's a small estate. Sometimes you can't even find out that information without filing the will for probate and then getting letters testamentary that allows you to go to the bank, contact creditors, contact a large firm that might be holding a 401k or something like that. Sometimes you need to open that estate just to find out what kind of estate you're dealing with, unfortunately. But the best practice is, if you've got a will out there and you've appointed an executor, is to make sure that executor has an idea, has the knowledge of where your bank accounts are, of what the size of the estate may be, so they can look at that ahead of time and possibly save the estate money when you go to probate it. Because if you're talking about probating the full will and going through the whole process through court, it gets a little more expensive than if you can file for a small estate. Mm-hmm. And there are other ways to pass assets too, which is something that, again, pre-planning for all of us, our impending deaths. I mean, as Jim Morrison said, no one here gets out alive. A little plug to the doors there, but the point is we all need to plan ahead of time to make sure that things can be passed easily to our loved ones, things that we want them to have. Real property, personal property, all those things can be taken care of. Bank accounts, to try and avoid them having to file with probate. But at the same time, you still need a will, you still need those other documents, powers of attorneys, healthcare power of attorneys, healthcare directives, and all that, for your planning, to plan ahead, to make sure that when someone loses a loved one, they're very distraught, very much in pain, and so we want to make sure that we have that plan ahead of time. So you've given your loved ones a roadmap of how you want things handled upon your passing, so you can avoid all these decisions on whether it is going to be a small estate or whether it's got to go through probate or anything like that. So I would suggest if you're dealing with that kind of stuff, thinking about this, or if you're dealing with somebody's estate or thinking about setting up your own estate, give an attorney a call. We'd love for you to call our office. We deal with this constantly. We have a good probate practice in our office, and we can help you through the process, and we can also help your loved ones avoid the process in the future.
All right, thank you. I want to squeeze in one last question if we have time, guys. So Chris, I want to throw one at you to kind of circle back into what you were talking about earlier.
Okay.
Can you explain what exactly an injunction is?
Okay, yeah. So an injunction is asking the court to either force someone to do something or force them to stop doing something, okay? Most commonly, it's forcing someone to stop doing something, such as if let's say your neighbor decides they're gonna build literally just, I don't know, some kind of noise-making machine, half on your property and half on theirs. They're halfway through construction while you were on vacation, and you come out and go, whoa, no, do not do this. And so you would file an injunction, and an injunction can be a permanent injunction, which is handled just like any other lawsuit usually, or you can more commonly do a preliminary injunction or a TRO, which is a temporary restraining order. But you have to attach those two to a request for a permanent injunction or to some kind of normal lawsuit. And what that does is you will have a hearing, and you will be asking the court to stop them in an emergency capacity from doing whatever they're doing. You have to be able to show that it's not just monetary damage that you're going to suffer. It has to be something else, such as permanent destruction, permanent damage, something very harmful that, if it's allowed to happen throughout the course of the litigation, is going to become either unstoppable, permanent, or increase the damage to almost an unconscionable degree. Okay. And that is what injunction is in short form. If you have more questions on that, ask us and I'll fill you in.
Thank you for clarifying that for us. And thank you guys for viewing in. We appreciate you. We look forward to you watching us every Sunday at 6 a.m. Again, if you have any questions, please submit it to legalhelp@jmmtlawfirm.com. We definitely review them. We would love to answer your questions on air, and we look forward to seeing what everybody submits. Thank you, everybody. Good morning and have a great day.
Thank you.
Thank you.